Broadcast is now starting. All attendees are in listen-only mode.
Happy Thursday, everyone. I just have a few announcements before we get started. Today's presentation is hosted by HR Simple in partnership with Burr and Forman. If you have any questions, please enter them in the question box and we will get to them. If you need to view a recording of the webinar or would like to view other webinars, please go to hrsimple.com/events. The slides and recording will be sent to your inbox within 24 hours. HR Simple provides federal and state-specific manuals. All of our books now have COVID-19 chapters, which include telecommuting policies and agreements, how to handle pandemics in the workplace, and the FFCRA poster. Today, you can use code FMLA60 at hrsimple.com to receive 60% off your purchase for attending our webinar today. And before we get started, I just wanted to run through Emily's bio. Emily concentrates her practice on labor and employment, education law, and complex litigation matters for a variety of clients. She has extensive experience assisting businesses and individuals with issues unique to the employment law arena, including matters involving wrongful discharge, retaliation, discrimination, harassment, and hostile work environment claims arising from a variety of laws, including the Americans with Disabilities Act, the Age Discrimination in Employment Act, the Family and Medical Leave Act, the Tennessee Human Rights Act, and the Fair Labor Standards Act. Emily has experience representing companies and individuals at the state level throughout Tennessee and in every federal court district in the state of Tennessee. She has also handled appeals at the state and federal level and appeared before numerous state and federal agencies. So I'm now going to hand things over to Emily so we can get started on the presentation.
Good morning, guys. Thank you for being with me this morning. We today are going to be talking about FMLA, the ADA in a new year, and some of the key developments that employers need to be aware of. As you might imagine, we are still talking about COVID, and some developments in connection with that will be a part of this presentation. I'm also going to try to catch everyone up on some of the non-COVID related developments that have happened, although there aren't very many of those that you guys may have missed as everyone was struggling to kind of keep pace with COVID developments and how those impacted managing employee relations, especially when it comes to leave. Leave under the FMLA, accommodations under the ADA, and all of those things. So we will dive right in, and if you have questions, please submit those and I will get to them as I'm able to in this presentation. So first, we're going to start with talking a little bit about some of the FMLA developments that have happened in 2020 and kind of forecasting what we're going to see as we move into 2021. One of the questions that employers had as people began shutting down office, having employees start working remotely, is what do we do? How do we stay compliant with our posting requirements? The FMLA is just one of these laws, but there are numerous federal and state laws that have continuous posting requirements, and I'm going to focus on the FMLA for purposes of this presentation, but know that there are others, including from a federal standpoint, things like the Employment Polygraph Act, the SCA, if that is a law that applies to you. So generally speaking, these are federal laws that require employers to post in a conspicuous place notices that give employees a notice of their rights, where they can file a complaint if they believe that their rights have been violated, and those must be posted, and employers must keep them posted. So it is a continuous posting requirement. Frequently, this is where we have our bulletin boards that are right by a time clock or in a break room, where they are regularly accessible by employees. Hopefully, we have not, you haven't allowed other employees to come in and put, lost and found or Girl Scout cookie flyers over those posters. But this is where you have your bulletin board that where typically, you're going to keep these notices posted. and it's going to keep us compliant in the event we do have some type of an inspection, especially an unannounced inspection. And so what do we do now with people working remotely, and how do we stay compliant there? So the EEOC, well, really the DOL, Wage and Hour Division, has issued some new guidance on this issue. The general rule is that these notices must be posted in a conspicuous place where employees are employed, and they must be readily seen by not just employees, but also applicants for employment. So that's something that's important to keep in mind. There are civil penalties that can be issued for violations. Although $176 doesn't sound like an exorbitant amount, keep in mind that each separate day is going to be considered a separate offense by these agencies. So it can add up quickly, and they can reach back in time as well, and those penalties can very quickly add up. So what do we do now, and how do we stay compliant if people aren't working in the workplace? Well, there's good news and bad news here. The good news is that you can supplement your posting requirements by providing and posting these types of notices electronically. But it is only going to be an acceptable substitute for those continuous posting requirements if these three requirements are met. And those include that all of your employees are exclusively working remotely, that all of your employees customarily receive information from you via electronic means, and all employees have readily available access to these electronic postings at all times. So if you have a portion of your workforce that is working remotely and a portion that is working on site, just only posting things in electronic form is not going to be acceptable according to the Wage and Hour Division. You still need to do the hard copy postings as well as the electronic postings. Only if your entire workforce is working exclusively remotely would replacing the bulletin board, so to speak, with some form of electronic notice be acceptable. And the other caveat that I'm going to throw in here is that in order for this to work and to be deemed acceptable under this bulletin that was put out by the Wage and Hour Division, employers have to provide employees with an effective means of providing the notice. You have to tell them where and how they are able to access the electronic postings. So if it's buried somewhere, on some type of intranet portal where it's not easy to find, it's not going to be deemed sufficient notice. So the practical considerations and the takeaways here are, do I think it's a good idea to go ahead and add these postings electronically? Yes, if they're easier to update that way. That way you stay compliant even if there's a change made and you don't have the most recent version of any required poster on your bulletin board, or people aren't going into the office and it's difficult to get those updated. Making them electronically available is going to be an easy way to provide those notices to your employees. You need to do so in a way that is going to be in an easily accessible place. I would also recommend updating handbooks to specifically reference or direct employees to where this type of information can be found. And then you have that acknowledgement form that shows where you gave those posting notice of where and how to access those postings. And then, the other thing not to forget about is some of these apply not just to employees, but to applicants and job applicants. So if you have an online application system, you're going to also want to include some type of resource there to where the employees can access those things and view them to make sure that you stay compliant in this area. We also received another field bulletin from the Wage and Hour Division this year that pertains to the FMLA. This one in particular pertains to telehealth or telemedicine visits. Under prior Department of Labor guidance, anything that involved, it had to be an in-person visit to qualify you for eligibility for FMLA leave. And what we're really talking about here is the definition of a serious health condition and what will qualify an employee for leave under the FMLA. We know that inpatient care that involves an illness, an injury, or an impairment that requires inpatient care is one of those qualifying reasons for the FMLA leave. The other one is continuing treatment by a healthcare provider, and there's several things that can qualify for for continuing treatment. But one of them, under the prior rules and regulations, the department was very specific and said it has to be an in-person visit. This guidance that was just put out on December 29th of 2020 changes this. It changes that rule and now formally recognizes that telehealth visits can qualify if they meet the criteria. This is a change from the previous guidance that was issued in 2008. And that is the guidance that specifically said to be in person, it cannot include a phone call, a letter, an email. And so this is a changing course from the Department of Labor, and I think it's a good one. I mean, I think what we are seeing now is telehealth being more accepted. I think it's going to be something that sticks around post pandemic to some extent, and so in certain circumstances it should certainly qualify, assuming the criteria are met. The criteria that the department has issued for when a telehealth visit can meet the continuing treatment requirements to qualify for FMLA leave are that it must be an examination, evaluation, or treatment by a healthcare provider. It must be performed by video conference. So again, still a telephone call, an email, text messaging is not going to meet that requirement. And then third, and finally, it must be permitted and accepted by state licensing authorities. So, you know, again, not a major development, but something to be mindful of as we move into 2021, that now telehealth visits can qualify for FMLA leave under the continuing treatment prong when these criteria are satisfied. Another development that is a little not as recent, but I think might have been missed by many of you, as again, people were kind of struggling to keep pace with all of the changes with the FFCRA and everything we all dealt with last year, is that the Department of Labor has issued new updated FMLA forms. Once again, it is not mandated that employers use these forms. They can use their own forms as long as they contain essentially the same information that is required that is on these forms. Some major overhauls were made to these. I suggest that if you haven't taken a chance to go ahead and take a look at them, that you do so and get familiar with them, because I think we're going to start seeing more FMLA requests this year, and it's good to kind of be on top of this as people start returning to work and other things. Some of the highlights with these forms are that they are fillable. They're fillable PDFs, which is nice and is convenient. So that's a nice kind of improvement to the forms. They also, on the notice of eligibility and rights, they will require an employer to indicate that if someone doesn't meet the hours threshold to qualify for FMLA, you are required to specify how far short the employee falls, which again kind of eliminates the questioning that may come back and forth from the employee by just providing that information on the front end if they are not meeting an eligibility criterion. There's also an option for the employer to indicate the effect that FMLA will have on employee benefits, other health insurance, things of that nature. So that's been in addition to the form, the rights and responsibilities form. It also requires employers to specify if the leave is going to run concurrently with workers' comp or applicable disability insurance that is required by state law. This is something that often employers forget to provide notice of, and then you can't go back and do it retroactively. So again, having this on the form that you provide at the same time, I think is a helpful reminder, to make sure that at the outset of any type of triggering request for leave, we know that that's been provided, and it makes it easier to not forget about that important step. Just some of the key highlights with the designation notice is that it outlines the steps that should be taken to amend something that is incomplete or insufficient. It's going to say it's insufficient, it's incomplete. Here's what you need to go back and do, to get us a sufficient certification form. And then it also makes it clear that employers are obligated to designate leave whenever there's a qualifying reason. Some employers in the past had a practice of allowing employees to, for instance, maybe use some paid leave before starting FMLA leave instead of running them concurrently. That was something that employers did. And this, we got some guidance from the department back in 2009, I believe, that said that that is not acceptable. If the leave qualifies, neither the employer or the employee has the option to delay any type of designation of FMLA. And so that these forms also add that statement. And then on the medical certification forms, there are some additional facts regarding the nature of the condition that qualifies the employee for leave, and also requiring the provider to give a best estimate, avoiding those of the duration of the leave and the duration of future treatment, really, which helps avoid some of those vague, terms that many of you all were used to seeing, things like indeterminate or that aren't particularly helpful when reviewing this certification form. So that it provides that encouragement to healthcare providers as well who are being tasked with filling these forms out. So again, there's some links here that have been provided to these. One of the updates that might have been missed, but I suggest everyone get familiar with them because I expect that we will be using them more this year. So I want to go over just a few cases that came out in 2020 involving the FMLA. As you all might expect, with the enactment of the FFCRA, we were seeing a lot of claims that got brought by employees who alleged that they were denied leave that they were otherwise entitled to under that statute, among other things, and also kind of lumping together traditional FMLA claims with the FFCRA claims. For those of you who don't know, the FFCRA expired on December 31st. It has not been extended. We are currently in a status that allows employers to continue to voluntarily provide leave under the FFCRA to employees who haven't already exhausted their entitlement, whether that is emergency paid sick leave or the emergency FMLA leave. So if you have, that is a voluntary thing that employers have the option to do through the end of March. And if they do so within that time period, then they can also continue to claim the tax credits that accompany that leave. But it's FFCRA for right now is gone in its current form, and it's not mandatory anymore. But I do think it's interesting to look at some of these cases that have came out involving it, because we're going to continue to see these claims. And I think especially as additional leave entitlements get passed, as we expect to happen with this new administration, new state legislatures also going back into session. It's nice to know kind of how plaintiffs' lawyers are interpreting these statutes, how they're bringing these claims, and how courts are dealing with them. So the first case we're going to look at here was actually a Eastern District of Kentucky case. This opinion was issued September 22nd of 2020. This employee was a substance abuse counselor who was asked, to stay home under a stay-home order by the employer between March 18th and March 30th. And that was, again, to give the employer time to kind of figure out how do we get in place some safety precautions with COVID-19, as many businesses did. The employee came back to work on March 30th, as she was required to do, but the following day, April 1st, she stayed home. And she started to cite as the reason for staying home concerns that that the employer was not taking sufficient measures to reduce the risk of transmission of COVID-19, and similar complaints. She also stated that she believed that this could put her family at risk, and she was dismissed that same day, April 1st. Plaintiff filed suit alleging interference and retaliation with her rights under the FMLA, and she also brought some claims under the FFCRA. Now, one thing to note here is that we refer to the FFCRA as kind of the main statute, but there are two different leave entitlements, and they run under different statutes. The emergency paid sick leave laws were actually enacted under the Fair Labor Standards Act, the FLSA. They don't have anything to do with the FMLA. Whereas the Emergency Family Leave Medical Act is the component that that was passed in conjunction with the FMLA, amended the FMLA, and it only provides leave for an employee who's unable to work due to childcare being closed as a result of COVID-19, as opposed to the emergency paid sick leave provisions that provided more additional reasons for leave for people who have COVID, who are subject to quarantine orders, and who need to care for family members impacted by COVID, et cetera. So with that background, the court dismissed this case just based on the pleadings alone at the complaint stage. And in doing so, it found that the plaintiff here failed to actually allege that she had ever sought leave under the EFMLA. Instead, these allegations were very much focused on concerns about returning to work, concerns about the health of her family, concerns that the employer wasn't taking sufficient precautions to protect her family. And so the court noted that even though the fact that this plaintiff happened to have a child, and that might have entitled her to some type of leave in the event that the child care was closed and there wasn't someone who could care for the child, plaintiff never requested leave. She never said, I need leave for this reason. Instead, kind of to the contrary, she kept reiterating that she was willing to work, wanted to work, but was only asking for precautions and steps to be taken, not to just not work. And so the court's holding here was that the plaintiff improperly equated demanding increased precautions before returning to work, which might have an incidental impact of protecting her school-age child, with requiring leave to care for the child under the FFCRA and particularly the Emergency Family Medical Leave Act provisions of that statute. So the next case is a District Court of Rhode Island case that came out at the end of November. And so in this instance, we have an LPN who was working for a nursing and rehab center. She actually contracted COVID while working, for her employer, and was unable to work for some period of time. Subsequently, the plaintiff sought paid leave from her employer under the FMLA, and a short time after seeking that paid leave, she was terminated. And so she alleged that she was terminated from her employment because the employer determined that she was not eligible for FMLA leave. And that was a retaliation claim is what she brought. The employer moved to dismiss the complaint, and it had a few big arguments here. First, it says, she was not eligible. She didn't meet the hours in service requirement to be eligible for any type of traditional FMLA leave. She hadn't been there long enough, and had worked significantly less hours than was the 1,250 hours required to qualify in the year prior. For the FFCRA component of this, the employer argued that she was an exempt healthcare provider. Again, she was an LPN, and that it was not required. She did not qualify for leave under the FFCRA. So the court, you might think, agreed with this, but it didn't, at least not at this point. The court said that she stated a claim for retaliation basically because she had asked for leave under this statute. She had sought to invoke her rights, and the fact that she wasn't eligible for it didn't necessarily mean that she couldn't bring a retaliation claim, based on the employer's termination of her shortly after the leave, her request for leave. So it's an interesting case, just because, even in these instances where we think we're in the clear, someone doesn't qualify and we proceed with adverse actions, employers need to be mindful of the fact that even if someone doesn't necessarily qualify for leave under a statute, they still might be able to get into a courtroom, and this employer is going to have to continue to defend this claim, which may ultimately be defeated at the summary judgment stage, but there are still costs and energy that go into those types of claims and defending them. So, interesting case, and I'll also note, the FMLA, unlike the ADA, the FMLA doesn't have an exhaustion requirement. So some of the cases that we have seen so far in 2020 involve the FMLA, whereas I expect that the claims that are going to involve the ADA and things like denials of requests for accommodation that are COVID related and all of those are still going to be working their way through the administrative remedy process at the EEOC level. So there may be some state complaints that have been filed involving those types of things, but it's going to be a little bit more into 2021, I think, until we start to see even filing of litigation that's going to involve the ADA. And then, of course, we're going to have to wait even longer for courts to kind of rule on those cases and evaluate those laws in connection with this pandemic that we've been experiencing, and see how these cases shake out. Okay, so now we're going to transition and talk a little bit more about what's been happening with the ADA in 2020, and then I'm going to read some tea leaves for you guys and kind of tell you where I think things are headed for 2021. In 2020, as many of you know, the ADA was all about, what can we do as an employer, okay? What do we have to do when it comes to accommodating employees? What can we do when it comes to screening employees for symptoms of COVID? Can we administer tests to employees and applicants for COVID? And I hope that by now everyone has sat through enough of these webinars to kind of have a good handle on those issues. We now have one of the things that we have gotten some pretty clear guidance from the Eeoc. If anyone hasn't taken a look at their technical assistance Q&As that they have been publishing, and they continue to update these and add to them and expand on them, I would highly encourage you to do so. I think it's going to be a key resource for employers as we continue to kind of navigate these gray areas and these unknowns when it comes to the pandemic and the ADA, because anytime we're dealing with health issues or something like vaccinations, that health issues and working from home or coming back into work and a pandemic, we are going to be seeing issues crop up with the ADA. So I would encourage you to take a look at that guidance if you haven't, and also kind of mark it to your favorites bar if you haven't already, because it's going to be a frequent resource for information. I think at least a starting place for some of this information as we continue to go through the next year. The things to watch in 2021, and I'm going to dig into these both of these issues in more detail, is number one, I think, as insofar as it concerns the ADA, it's going to be telework, remote work. And specifically what I'm talking about is many employers back in March kind of transitioned to having employees work from home. Some employers have now permitted people to come back in the office, some are still remote. And so as we start transitioning back into some type of a return to work scenario, what I expect is we're going to have more requests for accommodation. Employees with health concerns who, for whatever reason, are afraid to come back to work, don't want to come back to work. They've been working from home now for a year maybe, and want to continue to do that. And how do employers need to respond to those requests? One of the things that has come out of the Eeoc's technical guidance is beneficial for employers in this regard, but there's always the but. Okay, so the first thing, and I have this here on this first bullet point, is that the Eeoc has told us that an employer does not have to automatically grant a request for someone to work from home as a reasonable accommodation just because they allowed employees to work from home during the pandemic and are now recalling employees to the office. So it's not going, the right is not going to be automatic, but it's really going to turn on those essential job functions. So if you have permitted someone to work from home, and in doing so, you have voluntarily excused an employee from performing one or more essential job functions, then when the workplace reopens, you do not have to grant a request to work from home if it would require the employer to continue excusing that essential job function, right? We know from the ADA that in years of precedent with it, that the ADA does not require employers to eliminate essential job functions. The more difficult question is going to be, what is the essential job function? Can it be performed remotely? If it's been being performed remotely since last spring, and that there hasn't been significant issues with it, it begs the question, is it essential, or or not, or can it be reasonably accommodated such that requiring the employee to come back into the office would, requiring them to come back into the office would not be necessary because working from home could be a reasonable accommodation. So I think, once we've opened this door to remote working, there's been a lot of benefits that we have realized in terms of retaining talent and being flexible with employees, but we're going to have to continue to kind of carefully evaluate those types of requests, knowing that I think in many cases, an employer may be hard pressed to state that there are certain essential job functions that can't be performed outside the office when the business has continued and maybe the employee has been able to satisfactorily perform their job from home for some period of time. And that's, again, what also what the EEOC has said. That's the but part of this. Temporary telework is relevant. Employers can't ignore it. We can't pretend like it didn't happen. And we're going to have to take it into consideration in evaluating these things. So, one of the things that can be done here and should be done, and I know we all say this a lot when we're talking about the ADA, is to go back and look at those job descriptions, make sure that they are accurate, that they are up to date, that they list things that are essential job functions, so that when you receive these types of requests, you can more fairly evaluate them with those essential job functions in mind, because that's going to be your first kind of go-to document when you get any type of accommodation request. Is, well, what does the job description say? What are those essential functions? So the second area that we're going to get more into is going to be vaccines. We now know what we can do and can't do when it comes to the screening, but as we continue into 2021, it's going to be all about vaccines. Do employers require them? Does the employer want to administer them itself, or just require the employee to provide proof of vaccination? Do you not want to mandate them, but encourage them? All of these questions are going to be things that we are wrestling with, and companies are currently struggling with, in the first quarter. But the more widely available the vaccine becomes, the more it's going to kind of behoove employers to kind of come up with what their plan is, their approach, and then make sure that they are set up for success when it comes to implementation of these types of plans. So right now we have the current state of vaccinations is that there are 2 vaccines that are authorized. Both of them require 2 shots. Each state also has its own plan in place for prioritization, distribution, and allocation. So one of the things that employers are going to be dealing with is, if we do want to require vaccinations, when do we start requiring them? Do we wait until all of our employees qualify? Do we set, a time limit within the amount of time once an employee is eligible under their own state, then they have 60 days, 120 days, and these are going to be moving targets. Okay. We know that many people right now in certain states who do qualify aren't even able to get the appointments. So I think employers are going to have to be very flexible, in terms of, even if they want to have a third party come in and offer vaccinations, getting their hands on those resources. That might sound great in theory, but is it actually feasible given the status of the vaccine distribution? So those are things to be thinking about. And if you're a multi-state employer, there's going to be different considerations for each state that you're operating in, and even potentially different localities within that state. So another thing to know is that these vaccines will be provided at no cost. So any group health plan is going to cover the administration cost, and that is certainly something that can be put out to employees, to kind of encourage them to be vaccinated. If that's what you as the employer want to be doing. So digging in a little bit more on ADA implications as it relates to the COVID-19 vaccine. At the end of December, middle of December, we got some kind of unexpected guidance from the EEOC here. I think the prevailing thought prior to this guidance being issued is that the EEOC was going to take a very restrictive view, that the vaccination was a medical examination, that employers could only require it, when it was consistent with job necessity, which would really, potentially narrow the types of employers and positions to things like first responders and healthcare providers for employees who could be required or mandated to get a COVID vaccine. And the EEOC kind of didn't come out and say that. In fact, it gave us some guidance that is quite opposite from that, which was surprising. So under the guidance, the EEOC really hasn't said you can't mandate them, which kind of tacitly gives approval to say that employers can mandate the vaccination. Of course, there's going to be exceptions, and we're going to go over these. And one of them, being the ADA. Another being, potentially Title VII and any religious objections that employees have to being vaccinated. Those need to be, employers are going to need to deal with those issues the same way we would other requests for exemptions from other policies and in other circumstances. But the takeaway from the EEOC's view is that the COVID vaccine itself is not a medical examination under the ADA, and seemingly employers have the green light if they want to mandate that all employees get vaccinated. Where more considerations come into play are things like if the employer is going to itself administer the vaccine, because there are certain pre-vaccination questions that would likely get asked, and those could elicit information that pertains to disability, and that would then implicate the medical examination requirements under the ADA. Which again doesn't mean it can't be done, but employers, if you're thinking that would be a good idea for the size of your organization to have some type of on-site vaccination program, whether you're doing it or you bring in a third party to do it, that's something that you need to think about in terms of how do you think through those things, and how do you make sure that you're compliant and we're not asking questions that aren't necessary, and that any questions that are asked or documentation that's gathered is kept in a compliant manner under the ADA. So those are things to kind of keep in mind just in general about vaccinations and really the administration of them. The other component, and potentially I'll point out that also similarly requesting proof of a COVID-19 vaccination is also not a medical examination, not a disability-related inquiry. But once the employer starts asking, why have you not been vaccinated? That type of questioning is something that could be likely to elicit information about a disability. For that reason, it needs to be job-related and consistent with a business necessity. And so I think, as regardless of if you choose to enact some type of a mandatory vaccination policy, there needs to be a defined policy to go about how to request an exemption. You should probably have a form that goes with that. The form needs to be submitted to an appropriate representative, preferably someone in HR. It shouldn't be handed to an immediate supervisor who can then look at it and start asking questions off the cuff that we don't, are going to elicit information that we don't want our supervisors knowing. So that information, you need to think ahead of time about, how to implement these policies so that if you do have a mandatory vaccination policy and employees, you start asking for these proof of vaccinations, there's a procedure in place for employees to opt out or request specific exemptions for health-related reasons, religious-related reasons, things of that nature. So the other major component that's going to come into play when we start talking about vaccinations is just the exemption part of this. And what are our obligations as an employer when we're dealing with an employee who can't get vaccinated or refuses to get vaccinated, citing some type of a health concern. Again, our standard ADA laws are going to kind of be triggered by this. We have to provide reasonable accommodations to qualified employees, unless there is an undue hardship or direct threat that is posed to the safety of the employee or to others. Now, this was another area where the EEOC in its guidance kind of came straight out and said that a direct threat could mean that there's a threat that an unvaccinated person is going to expose others to COVID-19 in the workplace. But again, this is a case-by-case determination that is going to depend on each employer, and it's an individualized inquiry. The four criteria that employers are supposed to consider here to determine if an unvaccinated employee poses a direct threat would be the duration of risk, the nature and severity of potential harm, the imminence, and the likelihood that potential harm will occur. So once again, keep in mind that is, for instance, if everyone is working remote right now, and there's no imminent plan for anyone to come back, imposing some type of a mandatory vaccination policy would probably not be appropriate because there's no risk to the safety of the employee or others from a workplace standpoint that an unvaccinated individual poses. Similarly, if your workplace is able to kind of easily social distance, things of that nature, you need to consider as this is going to be, again, another moving target, because as more and more individuals do decide to voluntarily get vaccinated, the risk that an unvaccinated individual poses potentially goes down in relation to the other employees. So keep these things in mind, and as you kind of think through these policies and what direction you want to go. So I've laid out kind of a step-by-step analysis here for how to kind of go through a scenario where an employee says that they can't receive a vaccine due to some type of health condition. And again, this is assuming that the employer has opted to adopt some type of a mandatory vaccination policy. So your first step is going to be just like with any other request for an accommodation. You're going to request the supporting medical documentation from the doctor. That just substantiates the employee's claim that they have a health condition, that health condition makes it such that they should not receive a COVID-19 vaccine. Step 2 is going to be just doing that analysis that I just kind of talked through, the individualized assessment. Does this unvaccinated employee pose a direct threat to himself or others in the workplace? If the answer to that is no, because of whatever circumstances exist within the work environment, then the employer cannot exclude the employee from the workplace. If the answer to that is yes, then we need to go to step 3. Step 3 is going to be going through the interactive process, which many of you are familiar with, under the ADA, to identify any type of reasonable accommodation that could eliminate or reduce the risk so that there is no longer a direct threat. If that employee can continue to work from home, for instance, that may be a reasonable accommodation that would remove the direct threat. Similarly, if that employee could continue to do PPE, we could keep them socially distant. We can include things like plexiglass and all of the the measures we've already been taking as employers to kind of reduce the risk of transmission, and those factors would would reduce the direct threat. Then that is our obligation as the employer, is to determine if we can provide those. And once again, this is another area where the EEOC has really encouraged employers to be flexible, and it remains to be seen how courts are going to treat these types of cases where employees are denied requests for accommodation and some type of adverse action is taken potentially as a result, and employers are relying on these direct threat or undue burden exceptions, and see how that plays out in court. It's going to be still some time before we start seeing that. So the bottom line here again, and it bears repeating, is that even though the EEOC has given us some favorable guidance here saying, yes, you can require employees to be vaccinated, yes, an unvaccinated individual could pose a direct threat in the workplace, we have to be mindful of the fact that you still have to go through that interactive process. You cannot exclude someone from the workplace or take any other action like terminating their employment unless there is no way to provide a reasonable accommodation absent undue hardship that would eliminate or reduce that risk. So for this reason, many employers, and I think the EEOC came out in December, encouraging people not to enact mandatory policies, but to enact some voluntary ones. And so some considerations there that we need to be mindful of is, how do we do that in a way where we incentivize employees to get vaccinated, but also stay compliant? One of the things would be educating employees about the benefits of the vaccine, about its availability, having voluntary, again, people come on site to administer the vaccine, but it be, voluntary. We do that a lot with the flu shot. Once the distribution and the vaccines are more widely available, hopefully, those types of options will be more available to employers to make it easy for folks to get vaccinated. And then, consider some incentives. But I want to talk a little bit about the ADA wellness programs and the incentives and kind of the unsettled state of the law here. So at the same time, we have the EEOC come out and say, we really want you to encourage people to get vaccinated. We also have them issue a proposed rule on voluntary wellness programs. And what the EEOC has said, and this has kind of been been going on for a while here, is what type of incentives can employers offer for a voluntary wellness program that requires disclosure of medical information that does not violate the ADA or GINA, which is the Genetic Information Act. And so with this, we know that the law tells us that employee participation in these types of programs has to be voluntary. However, those statutes do not define voluntary. So this rule addresses what is voluntary in the context of a voluntary wellness program. And the guidance or the proposed rule that was filed by the EEOC is that a wellness program will be considered voluntary so long as the employer does not offer more than a, quote, de minimis incentive. The examples that were given here, and they're written into the statute, are water bottle or gift card of modest value. And that is in exchange for the employee participating in the wellness program. So prior to this, it was really common for employers to offer things like, an annual gym membership or significant deductions on health premiums, $25 a month, $50 a month, things of that nature to kind of encourage employee participation in these types of programs. Obviously there's still a lot of room for debate based on the proposed rule about what would be de minimis and what is not de minimis. But the EEOC takes the position that offering too much of an incentive here would make employees feel coerced potentially to disclose protected medical information in order to receive a reward or avoid a penalty. This rule was forwarded to the Office of the Federal Register for publication on January 14th of 2021. Normally, that would mean that once it's published by the Federal Register's office, which it wasn't, it would have been effective within after 30 days of the date of publication. However, we have had a change of administration, and this rule was not published, and that therefore I think it's probably going to be shelved right now because Biden has issued a regulatory freeze on any proposed rules and kind of halted them from going into effect. And so it's going to remain to be seen with this new administration, what the EEOC is going to do. Is this rule going to change? Will it go into effect? But something to consider as, again, we're talking about vaccines, offering incentives to employees to get vaccines, is to be mindful of the fact that this rule, is on the horizon and may or may not go into effect in its current form. So just kind of a summary here, just as we're kind of getting close to wrapping up, on what we've seen in litigation over 2020, what we expect to see going into 2021. So far, just over the course of last year, there were over 1,400 employment lawsuits that related to the pandemic specifically that were filed. Again, we are still at the very beginning of this, and I expect that we will see many more claims this year. Most of the complaints that were filed involved either discrimination, remote work, or leave of absence issues, unsafe workplace violations related to COVID-19 and lack of adequate precautions taken by employers. And then, we always see wage and hour claims, wrongful discharge claims as well. The most common ones, though, involved remote working and leave conflicts. So once again, I think, one of my issues that I'm highlighting for 2021 is going to be these, telework requests in light of the ADA. And this certainly signals that this is something we saw over 2020. I expect it will only increase as people come back to work, and companies kind of continue to kind of wrestle with those issues over the next year. I think other cases and claims that we're going to see are cases that challenge mandatory COVID-19 vaccinations. Again, the guidance we have is that, there's nothing that prohibits employers from doing that, but a court may disagree, in one context or another, or determine that there really wasn't some type of direct threat that is posed by an individual based on specific facts. And so those are things that, we'll have to consider and grapple with as well heading into the next year. And so I expect that will also be, another issue that we deal with and employers deal with, moving forward. So I think that's the end of my material. I've saved some time for questions. So if anyone has any questions, when I see some are in here, let me see if I can get to these. Let's see. Okay. The first question deals with an employer. It deals with the continuous posting requirements. One facility and employees are permitted to be in the office. There are workers all over the U.S. who work out their homes and service customers. We will not fly them to the office for COVID reasons. The only way they can see posters is to send them via email and put them on the company website. So although we do not meet the requirement for all workers are remote, we do not have a choice. Thoughts? I think the thought here is, again, you can use that electronic posting to supplement. So certainly do it electronically, and then also what it just means is that you can't take down your bulletin board that has the notices posted in a hard format as well. So I think that is certainly a way, putting them on the website, putting them on a company intranet page, is definitely a way to kind of accomplish this. The second question here is the same one. And then let's see, this one deals with vaccination. I understand that you can provide incentives for getting the vaccine. Can you punish an employee for not getting the vaccine? So again, this is going to deal with what is the reason the employee is not getting the vaccine. Is it related to a health condition? Is it related to a religious exemption? Is it related to something protected by law? And if it is, then we need to go through the process of determining is there a reasonable accommodation that can be made for that employee? And if we were to discipline or take adverse action against that employee, then there could potentially be a claim brought unless we properly went through that process, determined that there wasn't any accommodation that could be provided. But again, the devil's in the details with that. The documentation needs to be in order. We need to be making decisions based on objective evidence and not assumptions. And so that is something to consider. Now, if the employee just refuses and doesn't have a legally protected reason, then yes, the employer can enforce their policy if it is a mandatory one. I will also note that if you're going to adopt any type of policy that is mandatory when it comes to vaccinations, it needs to be uniformly applied and enforced. It can't, for instance, only apply to certain groups of employees, for instance, more high-risk individuals, which would also be older individuals, because then it is singling those folks out, and we don't want that from a policy standpoint. the next question here is about what if an employee won't take the vaccine due to religious reasons. There is a similar analysis for religious accommodation under Title VII as there is for the ADA. It is not, the law doesn't require as much from an employer when it comes to accommodating, a religious request, but I would recommend, I think best practice is to treat it the same way. We need to examine, is the belief, the religious belief sincerely held? If it is, then can that employee be accommodated, such as through working from home, wearing PPE, other measures that would reduce the direct threat that they would pose by being unvaccinated in the workforce. Is there a good source for downloading required postings? Yes, the Department of Labor has most of the posters on its website. Those get updated, from time to time. But I also think that, probably Google is your friend there in terms of providing, there may be some resources that kind of compile all of the different postings and have links to all of them on there. But the Department of Labor is certainly going to have any of the federal ones, and then just be mindful that there are often state posting requirements too, depending on what state you're in. And as you might expect, the more labor-friendly states, California, New York, tend to have more of those. Anywhere with a paid sick leave law is another state that there are often posting requirements that go hand in hand with that. So where would I find the required notices? Yeah, so I will be happy to kind of share a link to find those notices that will go out with the presentation materials if anyone's interested, for finding the ones that we discussed today. I think we have one more question here, and I think I have time to get to it. Someone sent this in touching on the religious question. For an employee claiming religious exemption, but really just has a moral issue against it, not really truly linked to a formed relation, how could an employer find this out? Whoo, that's a tough one. Anytime we get into issues regarding religion and religious exemptions under Title VII, it gets very hard because religion is such a personal thing. And there are some, and I would recommend kind of working again with counsel to do this in a compliant way. There are some questions that can be asked to determine, that the belief is a sincerely held one. But in most cases, in many cases, you may not have a good leg to stand on unless you're going to take a really, a really hard approach on those. That I would probably recommend in most cases proceeding to whether the request can be accommodated, as opposed to questioning whether the belief or religious practice is something that is sincerely held, or is getting into issues of whether it is moral versus religion-based. You are entitled to kind of ask about, what the basis for the religious belief is, and could even ask in some cases for them to provide, some type of scripture or a letter from a pastor. But we may get into circumstances where those things can't be provided just because of the nature of the belief that's being claimed. And so I would, in those instances, focus more on the whether the issue can be accommodated, as opposed to questioning the belief. In terms of people who are just scared of the vaccine, again, being scared of it does not exempt them from a policy, especially if you are a place like a nursing home. There's seriously, in that case, there is a serious risk that unvaccinated individuals could pose a direct threat to themselves and to patients and others in that type of environment. And, the recommendation, I think, and the best advice I can give at this point on that is doing your part as the employer to try to educate, try to reassure, try to, try to kind of gain compliance that way. And in the event, but in the event that the employee simply refuses because they're scared, if you have some type of mandatory vaccination policy, then you're going to be entitled to enforce it. Again, unless these legally protected situations come into play, which would require the interactive process and further analysis. So I think I made it through all of the questions, and we are about at an hour. So I really appreciate everyone's time. If anyone has questions, feel free to reach out, and I will do my best to answer them. But thank you for joining me this morning, and good luck in 2021.
Thank you so much, Emily. We loved having you on today.
Thank you.
And for everyone, if you have any additional questions for Emily or about the presentation, please feel free to email me. It should be up on the screen. I can answer any general questions. The slides will be going out by end of business tomorrow, along with the SHRM and HRCI code and a recording of today's presentation. If you do have any questions for Emily, you can go ahead and email her, or I'd be happy to forward those questions along to her. And thank you so much for attending, everyone. Have a great rest of your week.